Hello once again and welcome. So today we are looking at Gatley, page 1097, applications by defendant. If the particulars of claim disclose no reasonable cause of action, the defendant can apply to have them struck out and the action dismissed. Okay. He should, however, only take such a step where it is plain and obvious that the statement of claim as it stands is insufficient, and there is no reason to suppose that the plaintiff can improve it by amendment. Examples of cases where it would be appropriate to make such an application include cases where it is clear that the words were published on an occasion which was absolutely privileged, or where the words are actionable only on proof of special damage, and the special damage alleged is insufficient in law to sustain the action, or where the claimant's special damage claim is unsound in law. On any such application, the court decides no more than that the claimant's pleaded case is arguable or unarguable, and it does not follow from a decision to allow the pleading that the trial judge is bound to leave the claimant's case to the jury. If the question is one requiring serious argument and careful consideration, the defendant should not apply to have the particulars of claim struck out, but raise an objection in point of law in his defense and apply to have it tried as a preliminary issue. If the particulars of claim are insufficient, owing to the omission of some material argument, example, the words are actionable only on proof of special damage and no special damage is alleged, or if the claimant attempts to plead a true legal innuendo without setting out the extrinsic facts on which he relies, the defendant can apply to have the particulars of claim struck out, though the claimant, if he has a sustainable case, will generally, upon terms, obtain permission to amend. The practice sometimes adopted of withholding any objection until the trial is, however, a risky one and may involve adverse repercussions in respect of court. Okay, so let's take a look at that. In law, according to Gatley, on Libel and Slander, Maxwell, 11th edition, the defendant may apply to have the claimant's particulars of claim struck out where it is plain and obvious that the statement of claim as it stands is insufficient and there is no reason to suppose that the plaintiff can improve it by amendment. Examples of cases where it would be appropriate to make such an application include cases where it is clear that the words were published on an occasion which was absolutely privileged.